California task force to study and develop reparation proposals for African Americans. Content warning. It contains discussions of racial discrimination, sexual assault, torture, lynching, and other forms of extreme violence. Contains unedited historical quotations and photographs of white supremacist hatred, torture, lynching, autopsy, and other forms of graphic violence.
Historic gap in employment between black and white individuals is seen in California by every measure. Black Californians continue to lack access to labor markets available to white Californians and as a result continue to suffer harms that have compounded since before the founding of our country in March 2022, for example, the most recent data available. Unemployment rate was 10.5% for black Californians and 5.9% for white Californians. 372. Government protection. Its earliest days of statehood, California enacted a series of laws limiting the ability of African Americans to participate as full citizens of the state. As discussed in other chapters, these laws limited African Americans' voting rights, property rights, interracial marriage. In court or serve on a jury. 373. California barred the testimony of black individuals in both civil and criminal proceedings. 374. These laws left black Californians with little protection under the law, undermining their ability to advocate for themselves in the workplace, vindicate property rights. Bear witness to the crimes they suffered. 375. Discovery of gold in California. 1848 drew migrants from across the country and beyond. 376 African Americans were among them. A small group of black individuals established one of the earliest mining claims in Sacramento County, at Negro Bar, near what is now Folsom, on property once owned by William Leidesdorf. Afro-Caribbean businessman. 377 African Americans operated several successful mines, including Horncut Mine, a prosperous quartz mine in Yuba County, and the Washington Mine, a gold mine established in 1869. 378. Black miners faced a hostile environment because African Americans lacked the right to testify in court during this period. Black miners were vulnerable to legal challenges and encroachments on their mining. 379 frustrated by the discrimination they faced in California, including the state's discriminatory testimony and suffrage laws in particular, many black miners left in the late 1850s for gold fields discovered in British Columbia, though some returned to the United States after the Civil War. 380 to this day. Names like Negro Bar and Negro Flat are still used for locales in the mining region of California. 381 The California Department of Parks and Recreation currently operates the Negro Bar, Folsom Lake State Recreation Area. 382 However, it is working with local community and stakeholders to change the name. 383 Black mill workers played a significant role in the lumber industry from 1920 to 1960. 384 Experienced black workers were actively recruited from the South to staff California mills. 385 Although vital to their employers, black workers were paid less than their white counterparts and prohibited from undertaking supervisory duties. 386 The late 1800s and early 1900s, black workers were recruited from the South to work farms in the San Joaquin and Imperial Valleys. 387 Many black farm workers resisted the racist treatment they faced in California, and used contracted field work as a way to establish themselves as entrepreneurs. Workers, or yeoman farmers. 388 As a result, Californian farmers hire Mexican nationals and other non-white immigrants instead of black workers. 389 Additionally, growing towns and settlements during the time often explicitly discriminated against and worked to exclude African Americans from living or working there. For example, flyers for the Maywood Colony. Huge development entirely surrounding the town of Corning, California, trumpeted people. Communities in California you'll find Chinese, Japs, Dagos, Mexicans, and Negroes mixing up and working in competition with the white folks. Not so at Maywood Colony. Employment is not given to this element. 390. Early 1900s, black workers were less likely to work in higher-paying industrial jobs in the West than in the North. 391. By 1930, over 50% of black men were working in the industrial sectors of the Northeast and Midwest. And 30% in the West. 392. While industrial jobs often had significant downsides for black workers, they offered better pay than unskilled positions. 393. Still, many California companies refused to hire black workers. 394. For example, in 1940, aviation official W. Gerald Tuttle of the Vultee Aircraft Company in Southern California announced, "I regret to say that it is not the policy of this company to employ people other than the Caucasian race." 395. War period saw a significant influx of black workers and residents to California as the number of black residents increased in cities like San Francisco and Los Angeles. Black workers not only increased in number, but also began to move into professions from which they had previously been completely excluded. In California. Across the country, the Great Depression brought significant unemployment to the state. For example, manufacturing employment fell by 30% from 1929 to its lowest level in 1932, while payrolls fell by 50%. Employment among unionized workers rose to 33%. 396. The New Deal provided an influx of funding to the state. 397. For example, the Works Progress Administration employed over 100,000 workers in California. 398. Between 1933 and 1939, the government sent $2.2 billion to California in the form of grants and loans. 399. California governments engaged in discriminatory practices as the rest of the country did in dispersing this federal money. Burbank and Glendale invoked city ordinances to exclude a company of black workers organized Civilian Conservation Corps. 400 white residents of Richmond objected to an interracial Civilian Conservation Corps camp in 1935, until it was eventually replaced with an all-white company. 401. Organizing has a long history in California. 402. That over time has led to some of the nation's most worker protective laws. 403. The state first enacted its labor code in 1937. Provisions in existence. 404. California has repeatedly amended its labor and employment laws since then. Like the government, however, California for decades exempted both agricultural and domestic workers from various protections. Assembly Bill 1066, signed into law in 2016. Exemptions for agricultural employees that had been in place for hours, meal breaks, and other working conditions, including specified wage requirements, and it created phased and overtime requirements for such workers. 405. California enacted a Bill of Rights for domestic workers in 2013. Extending overtime pay rights to some. 406. But these workers remain without certain other protections. 407. Wartime integration and exclusion from unions. Workers made large advancements in the Bay Area during World War II, moving into manufacturing and industrial work in large numbers. By 1944, black workers were employed widely in wartime industries, especially in the shipyards. 408. For example, the city of Richmond saw a massive influx of war workers from 1940–45. Population grew from 24,000 to 100,000, with the black population increasing from 270 to 14,000 in those years. 409. Federal Employment Practices Committee, the federal anti-discrimination agency active during World War II, was largely ineffectual in California. 410. In 1945, FEPC reported, More than 26% of the Negro working force were engaged in shipbuilding or ship repair. Another 25% were employed in servicing water transportation, which was largely gov. Work. These two industries alone, the report concluded, accounted for approximately 12,000 Negro workers, 411. Even so, the Boilermakers Union, representing shipbuilders, allowed only white workers to join the main branch of the union. Relegated black workers to an auxiliary union, where they were not permitted to vote or file grievances, received limited benefits compared to white members, could not be promoted to foreman if the job involved supervising white workers. Were classified and paid as trainees even when qualified for skilled work. 412 in Los Angeles, the International Longshoremen's and Warehousemen's Union, Local 13, for example, excluded black workers. 413 even though black workers and organizations sued the Boilermakers Union for discrimination. 414. PPC helped reveal racist hiring practices at Los Angeles airline manufacturing plants. Hearings in 1941 demonstrated that there were only 10 black employees in Douglas Aircraft's workforce of 33,000, only 2 among Bethlehem Shipbuilding's nearly 3,000 Los Angeles employees. 54 among Lockheed Aircraft and Vega Airplane's 48,000 workers. 415 black workers' organizations helped push against this racist hiring to open more of these jobs for African Americans. 416. Ultimately, FEPC never recommended the cancellation of any defense contracts in California. 417 during and after the war, areas of California continued to experience job segregation. 418 for example, Oakland's employment patterns continued to have black men and women in separate, lower-skilled, lower-paid work. 419 when the end of the war brought layoffs, black workers were disproportionately impacted. By the end of 1946, 1/3 of all black residents in the Bay Area and 40% of black women were unemployed. 420. African Americans also migrated to California during this period to pursue farming, though they encountered setbacks similar to those in other labor sectors. Approximately 30,000 to 40. African Americans traveled to the San Joaquin Valley after World War II. The majority settled in cities such as Fresno and Bakersfield, and about 7,000 settled in the Tulare Lake Basin, farmland owned by J.G. Boswell. 421 Still, black field workers faced discrimination unlike their white counterparts. Were rarely promoted to operate machinery for higher pay, and were instead relegated to more demanding physical work for lower pay. 422 Moreover, like in factories, black workers also experienced greater injury and danger from farm work. 423. Employment and housing and short-lived affirmative action. Years before the federal government enacted its version of the law, California in 1959 passed the Fair Employment Practices Act, prohibiting employment discrimination on the basis of race by employers. 424 The present-day version of the law is the California Fair Employment and Housing Act. 425 The California Department of Fair Employment and Housing currently enforces the Fair AHA. Also prohibits harassment based on several different protected categories, including race. 426 The state agency investigates, prosecutes, and mediates complaints of discrimination. 427 California's support of the Department of Fair Employment and Housing has not been sufficient to meet the level of need. In 2013, the California Senate Office of Oversight and Outcomes reported that even though California had the strongest anti-discrimination law in the nation, the agency was funded with a relatively minuscule allotment of resources, which left the department unable to fully enforce the law and protect workers. 428 The agency's investigations of employment discrimination claims suffer from understaffing, poor quality, intake confusion, premature case grading. 429 The Oversight Office also unearthed a secret policy that had given the governor's office final say as to whether the discrimination law would be enforced against another California state agency. More difficult for government workers to bring a discrimination claim. 430 in the years since this report issued. The department's budget has grown, but the number of complaints it receives each year has also risen. 431. Federal agency hearings in 1941 concluded that there were only 10 black employees in Douglas Aircraft's workforce of 33,000, only 2 among Bethlehem Shipbuilding's nearly 3,000 Los Angeles employees, and only 54 among Lockheed Aircraft and Vega Airplane's 48,000 workers. Federal government agencies in California also implemented affirmative action programs in employment. These programs produced mixed results. For example, between 1977 and 1995, the representation of black tenured faculty members at the University of California system, which implemented affirmative action in its hiring, grew from 18% to only 25%, and for community colleges faculty between 1984 and 1991. Portion of black faculty only grew from 49% to 57%. 432. Affirmative action programs were banned in 1996, after voters passed Proposition 209,433. Proposition 209 amended the California Constitution to prohibit state institutions from considering race in hiring, contracting, and education. 434 according to polling data. 209 was supported by a majority of white and male voters, but opposed by a majority of African American, Latino, Asian American, and female voters. 435. Regarding Proposition 209's impact on employment opportunities is complex. In the 15-year period that followed Proposition 209 going into effect, the representation of African Americans, Latinos, and public sector relative to the private sector did not dramatically increase or decrease. 436 men and women of color working for the state of California continued to earn less than their white, non-Hispanic male counterparts and remained underrepresented in high-level positions. 437. 209's impact on the procurement process was more severe, as state and local governments were forced to abandon race-conscious contracting programs prior to Proposition 209's passage. Awards of public contracts to businesses owned by people of color and women had been rising, reaching a high of 88% in 1994. 438 by 1998, awards had fallen to less than 10%, and they never recovered despite the increasing diversity in California. 439. Study, published in 2006, found that only 32% of certified, minority business enterprises in California's 1996 transportation construction industry were still in business 10 years later, and among those that had survived, owned by African Americans had fared less well than others. 440. Another study published in 2015 found that Proposition 209 had led to a loss of between $1 billion and $1 billion annually for businesses owned by people of color or women. 441. As black employers are more likely than their white counterparts to hire black job applicants. 442. The closing of black businesses may have also hurt black employment. In California have worked to overturn Proposition 209, but have not been successful. In 2020, voters rejected Proposition 16, which would have repealed Proposition 209,443. Occupational licensure in California. Nearly 21% of workers in California must obtain a license to work in their jobs. California required workers to obtain a license for 61% of lower-income occupations, ranking it the third most restrictive state nationwide, following only Louisiana and Arizona. 444. California withholds or restricts access to licenses from persons with certain criminal convictions, which is more likely to harm black residents. For example, as discussed in Chapter 11, some incarcerated Californians participate in a program to help battle wildfires. 445. Upon release, however, Program participants would not be eligible for jobs in many fire departments because they cannot obtain an emergency medical technician (EMT) certification. 446 California law specifically prohibits EMT certification for anyone who has been incarcerated for a felony within the past 10 years. Disqualifying many people who participated in Fire Camp 447 in 2020. Recent attempts to remediate these issues related to firefighting have had limited success. 448. California has made some strides in lifting restrictions on occupational licensure in recent years, with the passage of AB 2138, which prohibits California licensing boards from denying a license for, among other things, many convictions older than 7 years and dismissed convictions. 449 While AB 2138 represents progress, other schemes remain in California which continue to have a racially discriminatory impact. 450. 13, a California government watchdog office reported that even though California had the strongest anti-discrimination law in the nation, the state agency tasked with investigating complaints was funded with a relatively minuscule allotment of resources, which left the department unable to fully enforce the law and protect workers. The agency's investigations of employment discrimination claims suffer from understaffing, poor quality, intake confusion, and premature case grading.